Campos.
Good morning. May it please the court. Kara Rockenbach on behalf of the Citizens Property Insurance Corporation. I'd like to reserve 3 minutes for rebuttal.
Okay.
This appeal presents a textbook case of a trial judge coercing a lone holdout juror to compromise her heartfelt belief.
Well, didn't your client request the Allen charge?
We did, Your Honor, absolutely.
Isn't that a bit of a problem for your opening?
It isn't, based upon the totality of the circumstances that this court has to look at. And the key point in the trial transcript that this court must focus on, it's a very short colloquy with the jury, despite the fact that the jury came back 4 times. But the key point in the record is that the trial judge said, I need you to reconvene to answer that question. The effect of this statement after the Allen charge was to single out that lone juror. If I could back up, the jury was out for about 2.5 hours when they first came back and said, they announced the numerical split. They said we're 5-6. They meant 5-1, but they said we're 5-6 in favor of the plaintiff, but we have a problem with the number. And they actually said there may have to be a mistrial, almost as a prediction. And the additional note says, can we award any less than the $99,000? The 99 was the low end of what was presented for damages. It was the low end of the subsurface plus the cosmetics. The court said, that's the first instruction, the court says, the court directs the members of the jury to read page 7 of the jury instructions, which is the standard 601.1 weighing of the evidence. This is a written note. Everybody agrees. The jury comes back after about 45 minutes. This is the second time. And they say, they don't have to, by the way, use the magic word, we're deadlocked. But they say, we cannot agree on a verdict. That's a deadlock. And then they again tell the court and the lawyers of their numerical split. They announce it. We're now 5-1. And there is a member. They single out, these jurors actually single out this juror, and they say there is a member of our jury who does not agree with the amount of $99,000. 5 of 6 of us are in favor of the plaintiff. The jury member wants settlement amount lower. We explained that this is not for us to decide. And yes, Judge Black, you're correct. That is the point when Citizens Counsel says, and we, by the way, at the first question, everybody said, hey, is this the time when we should be given a deadlock? It's plaintiff's counsel, Mr. Smith, who says, I think there's an instruction on this. And the judge says, I don't think we're there yet. But the second time, when they come back into the courtroom, that's when Citizens says, yes, we want 801.3.
But Citizens never does register any objection to the proceedings until the last question. Isn't that right?
That's correct. That is when Citizens moves for a mistrial.
Up until then, everybody's on the same page. In fact, Judge Wolf is very conversant with the parties. This is what I'm thinking about doing. What do you think about this? Are you okay with this? Are you on board with this? And everybody's on board until the very end.
Not entirely. And I would refer the court to the supplemental.
Refer me.
Okay, thank you. Refer the court to the supplemental record, page 117. And I'm going to go ahead and fast forward because that's the Allen charge is given. And then the jury comes back and they answer the first question, the liability question, and they don't have anything for damages.
Yeah, but the Allen charge is when they're deadlocked. They come back with a unanimous verdict in favor of Campos. There's no doubt about it. It's a unanimous verdict in favor of Campos. There's just no damages.
No damages.
There's a distinction. There is a unanimous verdict. There's just no numbers because they've already erased what they thought was appropriate. So I don't know how you can argue that that is a deadlock.
It's actually a partial verdict because a unanimous verdict would mean that they came back with a unanimous answer on 1 and a number on 2. But they have erased the number. And the reason, Judge, is that from the very beginning, they can't agree on the number. They're deadlocked from moment 1 on the $99,000, which is evidenced in the ultimate reward or award of $70,000. That's a compromise number. The facts of this case squarely meet the Madsen case from the 4th District Court of Appeal, where that court reversed the jury verdict based upon the compromise number. In that case, factually, identical to here, the jury was deadlocked on the number. So there wasn't a unanimous verdict with regard to the damages question, and that's the problem. But to get to that point of the...
Why is it you're asking for a new trial on everything then, instead of just damages?
Because there's no indication of what this jury was doing with regard to, perhaps this lone juror didn't even feel that there was, that she agreed with the liability question. So you can't just, You can't, that's a good question, but I think based upon the error that occurred with the coercing of this lone juror, and to get to that point, that was the instruction.
But they're clearly in agreement, because the question the court reads is, we need, off of what the jury sent out, is we need to know what our dollar amount choice is. They don't talk about anything other than how much.
That's true, they don't. I mean, they're coming back and they are stuck on, and they're stuck from day one on the number issue. But Judge Black, you asked me to refer you to that point in the record where Citizens is saying, no, stop this train.
Right.
And that's page 117 of the supplemental record, page 1122 of the trial transcript. And this is the last time, this is after the Allen charge. We know, based on Tomlinson.
I'm looking right at the page. What specifically?
Okay, Mr. Rock says on line 21, they just need to understand they need to deliberate.
Mm-hmm.
If they can't fill in a number, it's a mistrial. He's got it. There's nothing in the law that...
But he doesn't ask for a mistrial.
Not yet. He does
Yeah,
after...
but he says that after. On page 116, he says, please complete the verdict form as you were previously instructed. That's what he tells Judge Wolf to do.
That's
and then he keeps on. He maintains that position and says, the court says, so your position is I should simply tell them they should go back and finish the verdict form. Mr. Rock, yes, sir, consistent with the court's instructions. That doesn't preserve any objection whatsoever, and that's not a motion for a mistrial.
It isn't.
And then the discussion of mistrial is simply exactly what it is. It's a discussion. That's not preserving an issue. That's not moving for a mistrial.
Well, if you continue, actually, when the jury comes back, Your Honor, after that, and the judge, by the way, the instruction that the judge says after what you just read, the judge then singles out that lone juror and says, I need you to answer that question.
How do we know that?
That's in the, that's
Does he
right.
call the juror by name?
No, but he doesn't
How do you
say.
know that? Because I've instructed jurors for 7 years, as Judge Black has, and we look at them and say you. Sometimes I say y'all, because I'm from the South. But it's always singular. So how can you argue that he's actually looking at Miss Smith, who's over there trembling because she's the holdout?
I thought of that same question this morning, Your Honor, and knowing Judge Wolf being a Southern gentleman also, didn't say you all. And there's no reference in the trial transcript that he singled out the female juror. There isn't. But the fact is that from the outset, we know that it's a 5-to-1 split. Everyone knows. The jury knows, the lawyers know, and the judge knows that there is one single holdout lone juror. So he doesn't have to say you singularly, Miss Smith. He knows that there's one person, and he says to her, and this is the point where we preserve it, and we ask for a mistrial very clearly, very plainly. Mr. Rock comes in, and the jury comes back and says, we need to know what our dollar amount choices are. This is after the judge says, I need you to reconvene. So this lone juror is back in the jury room.
Really, it sounds like their debate was more about could they award less than the specific numbers? Could they just pick their own number? What were their constraints? Not like she was holding out. I mean, she obviously agreed that Citizens had liability. So it's just a question. I think it sounds to me, when I look at this record, more like the debate was what were their legal constraints in terms of choosing a number. That is, from the record, there's no indication about the liability question. I agree. The jury is struggling from the outset when they have the 5-to-1 split over, we can't agree on the $99,000. But that is what the flaw is in this colloquy. The judge cannot, after giving an Allen charge, and the jury comes back and says, what are we going to do here? We are really struggling with the numbers. The judge can't send them back. And that's where Citizens moves for mistrial and says, this is wrong. You can't tell the jury to deliberate after deadlocking following an Allen charge. But there's also an issue with regard to the numerical split under LeBron versus State. The Florida Supreme Court has said once you know you've got a numerical split, we can't give an Allen charge based upon the fact that it's going to single out the minority. In this case, it's not just a minority, it's a single juror who's been singled out repeatedly, but most significantly, the last 2 times. The one time where Judge Wolf says, I need you to answer that question, and then when they come back and say, what are our choices? What are our numerical choices? And the judge says, go back and read the damages instruction. This juror is not told that she doesn't have to agree. She's being told that she has to answer that question and complete the verdict form. That's contrary to Florida law.
But they've already been instructed they don't have to agree. They've already been instructed they can base the damages on what's been proven at trial, what's reasonably certain to be incurred in the future, what's been reasonably proved for the past, et cetera, et cetera.
Originally, yes,
But
that's
they've already been
correct.
instructed that.
Originally, yes.
And Campos didn't, or Citizens Council didn't ask for a re-instruction on that issue. What Citizens Council did was asked for an Allen charge. An Allen charge is for when the jury comes back and says, Judge, we cannot make a decision.
Right.
He asked for that, and it met its purpose, because when the judge says, do you have a verdict? They said yes.
But they didn't.
They said yes.
They said yes, but they didn't. They came back with only one of the questions answered. That's a deadlock. They didn't answer the second question.
Do you have a case that says that is a deadlock when they say unanimously, we have a verdict on the legal issue as to who is legally liable or who is at fault, but they haven't come up with damages?
How can you
Aren't we talking about an incomplete verdict as opposed
Absolutely.
to a deadlock?
Well, it's a deadlock on question 2, but it results in an incomplete verdict.
Well, in an incomplete verdict, you've got to make a contemporaneous objection and tell them to go back.
But what occurred here was the coercion aspect. When they come back, they're really deadlocked on the verdict, Your Honor. I agree with you, and it might be semantics. I agree that it's an incomplete verdict. They didn't answer question 2.
You know, I guess one of the things that's bothering me about this, well, there's a lot, but one of the things is they came back with a number that was less than even the lowest damage figure, but you're here
Correct.
Complaining about it.
Because it does.
I mean, I notice you're not arguing that the verdict wasn't supported by the evidence. You're
Well-
not challenging the 70,000 number. You're challenging the fact that the judge required them to fill in a number at all.
The plaintiff moved for remit for editor. The plaintiff actually, post-trial, is making the argument that I'm making here, that it did not, that it was contrary to the evidence. So the plaintiff made that argument.
But how were you harmed ultimately? Because the jury was unanimous in finding liability.
I'm harmed.
And they ultimately came back with a number that was in your favor.
Not really. It was a number that was contrary to the evidence.
Well,
There's
it was
nothing to
lower, it was lower.
But that doesn't mean
What, you
that-
would have preferred a $99,000 verdict?
No, I would have preferred that the one lone holdout juror who had heartfelt beliefs in not being able to arrive at a consensus would have been told that she didn't have to. We have the constitutional right to a fair and impartial jury. And the key here is that this lone juror who is saying,
Well, it sounds like she won out because they came back with
well,
70,000 instead
we
of
don't know, maybe
99.
she wanted a 0. Maybe she wanted 10,000. Maybe she wanted, who knows if we won out? Really, we're speculating because all we know is that one juror was not able to arrive at a consensus, but was repeatedly told
what we do
she had
know
to.
is we had a unanimous verdict
On
against
li-
your client on liability. And what we also know is that the lowest figure that the jury could have chosen, you know, that was supported by the evidence was 99,000, and they came back with 70. So tell me, other than speculating, how are you harmed?
Well, harm based upon the fact that this juror did not want to award any money, perhaps, potentially, and you're right, we're speculating that she won out when they put 70
Well, don't you
down.
have to convince us that you were harmed?
I have to convince you that, and after an Allen charge was given, that the jury was improperly told to go back. And that's the key. This lone juror was told, you have to go back. They were sent back after they came back following an Allen charge. And once an Allen charge is given, under Tomlinson versus State, if the jury comes back in, it's over. The case is mistried. Citizens did move for a mistrial, and albeit it was potentially, it could have been earlier, doesn't mean it was waived. It was made, and it was preserved. It really does match the facts of the Madsen decision. The Madsen case was exactly, and I do understand the panel's concern that the fact that the liability question was not at issue, but that's identical to Madsen. In Madsen, the liability question wasn't at issue. It was the damages question. And the 4th DCA said, no, this number that they ultimately awarded after the Allen charge was given, after they came back and they were deadlocked, it doesn't match the evidence. It's contrary to the evidence in the law. So the 4th DCA concluded and reversed that verdict, even though it was unanimous on liability, and said that it was a compromised verdict based on the number, the contested liability, like in this case it was contested liability in terms of coverage for sinkhole. this case this court has also spoken on the issue, Goodwin versus State, and said it was reversible error to admonish the jury, make it clear that they have to reach a verdict. That's the distinction or key. The court doesn't...
You're running out of time, and if I could ask you to switch gears and talk about Tower Hill and McKee and,
yes,
and Phillips.
Thank you.
Yeah.
Thank you very much. You both were on that decision. Judge Sleet authored the opinion, and Judge Black, you were on that. And I know counsel and I have read the briefs for that. The opinion doesn't indicate that it involved a neutral evaluation scenario, but the opinion is clear from this court that it was a denied sinkhole claim, just as this one was, and the plaintiff moved...
You had me confused for a minute. It was actually Judge Kelly that was with...
I'm sorry.
Okay.
I put you on it. I knew it was two of you, and I knew Judge
I
Sleet
don't
authored
remember
it.
being on that, and
I'm
Judge
so
Sleet
sorry.
was so proud of his opinion, he wanted to hear you talk about it.
Listen, you're eating up her time. Go ahead.
All right.
I'll give
Well,
you some extra.
Judge Sleet and Judge Kelly, you got it right in the Tower Hill versus McKee case. And I'm sure Judge Black would have agreed with you if you'd been on that panel. But the Tower Hill versus McKee case is so significant to this area of the law. It really is, because the goal and purpose behind the sinkhole statutes, and as this court has heard from numerous lawyers, it is a statutory framework. And the goal designed behind it is to fix the land, not to give a cash payout that is used for a cruise or a car.
Mr. Elligott's going to stand up here in a minute and talk about the Coucher case and how there's a pleading requirement. So why don't you address why Tower Hill should control this case in the absence of a pleading?
Okay, well, in this particular case, although it didn't involve a neutral evaluation statute, it is akin to the appraisal case in the 5th District Court of Appeal, Judge, that you mentioned, the Phillips decision, it's Phillips. But basically, it doesn't matter whether a case goes to appraisal for conclusion, to a final judgment for conclusion, to a summary judgment, or to neutral evaluation. It is conclusion of a sinkhole claim. And the goal and design behind the statute, 627.707 subparagraph 5, is to hold back the money for the subsurface repairs until the insured enters into a contract. Then the money is given, because the goal is to repair the land. And that's what this court said in Tower Hill versus McKee, essentially, in reversing that aspect of the summary judgment and requiring the contract. Our policy, citizens' policy, is similar to, almost identical to Tower Hill's policy with regard to incorporating 627.707.
Yeah, that provision's in there, and I understand
Yeah.
the statutory provision. My question would be, citizens didn't request an interrogatory type verdict.
Right.
It was just simply a general verdict as to damages. There's no distinction as to subsurface or cosmetic repair
Right.
amounts.
Well,
is that almost a waiver?
a great question, because it wasn't raised in terms of like the two-issue rule, but that's somewhat the concept. In this particular case, I think I've lucked out because the court granted a directed verdict on cosmetics, and it was a finite amount of $24,000. So you can clearly figure out from this $70,000, which is not based on any evidence in the record or correlating to any evidence in the record, which is why we're requesting reversal. But you can clearly take that directed verdict in favor of the plaintiff on cosmetics for 24 and say the remainder has to be for subsurface. This really goes to the heart of why there should be a requirement that they enter into a contract for repair of the land, because whether it's a verdict that is not separated or a verdict that you can determine what the amount is in the subsurface, the goal is to repair the land, and it's a public policy public safety issue. We don't want another Sefner, another issue. So this is not just, and I would make one additional point. There is no other area in the insurance code that so regulates an insurance company's actions on how to investigate a claim. There's no area in the insurance code that allows an insurance company to hold back, other than the prejudgment statute where factors are outside of our control that you referenced in the Tower Hill versus McKee decision. This is key. It's a public safety reason and public policy reason why insurance companies are allowed to hold back on the subsurface repairs until the insured enters into a contract. And there should be no distinction between whether it is a final judgment following a verdict or an appraisal, which is also an adjudication, or neutral valuation statute, or neutral valuation
You're
process.
at your
Thank
3
you very
minutes.
much.
Okay, thank you.
Good morning, may it please the court. I'm Tom Elliott of Buell and Elliott here on behalf of the Campos. Unless there are questions on issue 1, or actually it's a later numbered issue because there were 2 issues withdrawn, but unless there's a question on the verdict, the only comment I would make is that I don't see from the questions that it's a woman that's the holdout, although when I look at the names, I don't see from the questions, but when I look at the names of polling the jury in the back, it does look like 5 out of 6 were women. So I'm not sure what the significance of that is, but I didn't get it from the questions that it was directed to a woman, although I guess the odds are 5 out of 6 it was. On the contract for repair issue, there are 3 major differences between this case and McKee. And I think this is a good opportunity because I can tell you from what I know, there are more of these cases percolating up to your court, and it's out there, and McKee is being used in a lot of different ways. And this is a chance, I think, to clarify. And maybe I'm wrong, and Citizens is right, and that's exactly what this court means. But I think there are significant distinctions between this case and the setting of this case and McKee. First, before we get to that, procedurally, there was a waiver here. They did not, what affirmative defenses Citizens pled were withdrawn at trial. The ones that pled didn't cover it. Coucher, as Judge Black noted, says you have to plead a limitation. Citizens' reply brief says, oh, well, we're not trying to deny coverage, we're trying to pay by requiring a contract.
Was this really a limitation?
Phillips says you're permitting the carrier.
It's a method of payment.
Phillips at page 508 says this is a method that permits the carrier to limit payment. So yes, Your Honor, it is when you say, okay, I owe you the money, but I'm not going to do it until you jump through these additional hoops, that's a limitation. So the other thing is that it is unlike, Citizens say well, that actually moves to the second point, because they're saying, well, we want to pay. No, they really don't. And in this case, there were 2 other issues that they've withdrawn from the moment because of the Munoz case, which they're still seeking review of in the Supreme Court. But Munoz did away with their claims presumption and their burden of proof arguments, both of which they were arguing to get a new trial and to continue to deny coverage. As we stand here today, they do not admit there's a sinkhole in this property. They would like to not pay at all. That's why they want to have a new trial. They want to go ahead and do the whole thing again, including liability. So we're here on a denial, a case that went to trial on a denial. We are not here on a neutral evaluation, and we are not here on an appraisal. That's a big difference, because that means we are governed by the loss payment provision and not the loss settlement provision, which is what this court addressed in McKee. In the provisions in the policy, the loss, if you look at the sinkhole endorsement, which is page 55 of the policy, it changes things in the policy, some things, and including the loss settlement. It says the loss settlement provision is amended, and they change it. And that's the only part of the policy that says, okay, we can insist on a contract for repair. The loss settlement provision. Then at the end of the sinkhole endorsement, it says all other provisions of this policy apply. All other provisions apply. So if they haven't modified, it still applies. The loss payment provision is a different part of the policy. It is on page 44. And what it says is we will pay you 60 days after we receive your proof of loss, and 1, there's an entry of judgment, or 2, there's a filing of appraisal award or a mediation settlement with us. Now, in the sinkhole endorsement, they take away mediation and appraisal. They say, we're not going to do that anymore. They say, we'll have neutral evaluation. So, and neutral evaluation is what was involved in McKee. When it is one situation when a carrier says, I don't know about that, I'm not sure, and there's neutral evaluation, the carrier says, okay, there's a sinkhole, we'll pay. That's the McKee scenario. That's not the scenario here. In McKee, and again, you're familiar with it, you can go back and look at it, in McKee, the insured did not argue that the loss payment provision applied. They said we're under the loss settlement provision. And again, you can harmonize those. The only way you can harmonize those, I think, when you go all the way through trial on a denied claim is to say, okay, once you have a judgment, the judgment's controlled by loss payment. The loss settlement provision does not let them do that because they have not agreed to settle the claim. They have been forced to pay the claim after breaching the policy by denying coverage. And that is the third distinction between this case and McKee. Because in McKee, okay, maybe they did have an initial breach at the beginning, but they saw the light. They said, okay, neutral valuation, yes, there's a sinkhole, we agree, we'll pay. And here's how we're going to pay. We're going to pay, fix the ground, and we'll pay you the above. That's fine. That's what happens in neutral valuation should happen. I have no problem with it. But here, they have still not admitted coverage. They are still denying the claim. That puts us under the Judge Buckley's, the rationale she explains in the Lumpew case. I'm probably mispronouncing that. But she explains, citing to Florida law, once there has been a breach, all damages can be recovered. That is kind of a corollary to once they breach their policy, they can't insist on the insured meeting these other conditions. And this is a condition/limitation on payment. So those are significant distinctions, we would say, I would say, to McKee and this case. Three significant distinctions. And I would hope, I'm happy to take a win any way I can. So if it's lack of preservation because of, but I would hope the court might take this opportunity to go ahead and say, look, just to clarify, McKee dealt with this situation. There are other situations that it doesn't deal with, like a denied claim that goes to judgment. Because I think when you work through the policies I've discussed before here, you see that you are left with a situation where the denied claim that goes to judgment is covered by lost payment. And that's consistent with the rationale that once you breach the policy, it ensures the other parties entitled to get all their damages. Unless there are any questions?
No, thank you.
I would ask that you affirm. Thank you.
Thank you.
Judge Black, you mentioned the Coucher decision. This statute is not an affirmative defense. It is Florida law. And we raised it before the trial in a motion to enforce Florida statutes, not just our policy. We said Florida law says that we should hold back for subsurface repairs until you enter into an insurance contract. Judge Wolf, or it might have been another judge, because I think there were 4 judges who handled this particular trial, and the trial itself, but before trial there might have been another judge, denied that motion. So this was not something that was not preserved. We raised it by motion. And then following the verdict, we asked the judge, please enforce Florida statutes. So this is clearly not waived. It is similar, and almost with the exception of not involving neutral valuation, it's on point with Tower Hill versus McKee, because both this case and the McKee case were denied sinkhole claims. Denied sinkhole claims. This is not a situation where McKee was accepted coverage and dispute over method of repair. They both were denied. The loss settlement applies because it's more specific. We know in insurance coverage or insurance law, when you go to a policy, if there's a more specific term, that term governs. This is a sinkhole endorsement. This is a sinkhole claim. It's not a general property claim. So the endorsement for sinkhole covers, and that's the loss settlement provision that this court looked at in McKee, that we're asking this court to look at in our case. The loss settlement provision is the one that says we can hold back until the insured enters into a repair contract. So the statute is the law. It's a requirement that the insured follow the law before money is owed. It's not a condition that is somehow waived or required or waived when the jury finds that we've breached. This case is no different than appraisal. Appraisal and final judgment are both referenced in the main policy and the loss payment provision. But State Farm versus Phillips in the 5th DCA, which involved appraisal, they went to the more specific endorsement for sinkhole, the provision that governs sinkhole payments, and they said, yes, insurance company State Farm should hold back for subsurface repairs until there is a repair contract. I understand the court's concern about, to just go back for a moment about and I know I'm probably out of time, but to go back for a moment about the juror, the lone juror holdout.
Can I ask you one more question first? What if we didn't have the scenario where there was a partial directed verdict here, there was just a money judgment? What would we do?
Going forward, I might advise a request for a differentiated verdict form, because I think it's obviously more easy for a trial judge to say, you get an immediate payment of 24,000, and for the remainder, you've got to enter into
But
a
I mean,
contract.
if the numbers weren't distinguished like they are here, how could we do what you're asking us to do?
Well, it still requires an insured to enter into a repair contract, and I understand, should be an immediate payment for the cosmetics. We can't hold back on cosmetics, we can't. The law requires that we advance that money, that's owed for the above ground. So it's problematic. If it's, to be candid, I would prefer it to be differentiated. But in this case, like I said earlier, I think I lucked out because the court directed a verdict on the 24,000. This was a denied case. Citizens didn't come in and say, well, it's going to cost X to repair this land. We were saying there's no sinkhole at all. So
Okay.
so there was no evidence with regard to
You
the
need to
20
wrap up, please.
Okay, thank you. Just want to go back very quickly about that lone holdout juror, just one point. I think the error or the wrongfulness of telling this juror to go back and answer that question is underscored by the fact that everyone in the courtroom knew that it was a 5-to-1 split. It wouldn't be as egregious if it was, we can't
Okay,
agree
I'm
that
sorry.
there was one.
You're at the end of your time.
Thank you very much. We
Thank
ask you to reverse and write on the repair contract issue.
Thank you.
Thank you.
Good job.